Good morning. This is the Colorado Energy and Carbon Management Commission. It is August 12th and it's 9 a.m. and we will start with the roll call.
All right. Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Robbins.
Here.
Commissioner, you have 5 of 5 commissioners.
Great. Thank you very much. Good to see everybody. We have one item on our agenda this morning. That is docket 2405000115, the deep geothermal rulemaking. Would remind everybody kind of the status of this. We had taken this up last week for a day or two. We had feedback from commissioners. We heard from all the parties. We had feedback from commissioners to staff. On Friday afternoon, around noon of last week, staff issued a red line version of the rules and the statement of basis and purpose. And we are taking that matter back up this morning for final consideration by commission. Looking to see if Mr. Boudreau is available for us. He is our Attorney General that is assigned to this docket. Mr. Boudreau, would like to recognize you for, I don't need you to go through the rules, but just to kind of echo, did I get kind of where we're at in terms of this morning's docket and the procedural posture that we're at?
Yes, Mr. Chair, that's right. Over the last week, staff incorporated the instructions from the commission in both the rules and the SBP. We filed those into the docket on Friday. I believe they were also posted to the portfolio, and the commissioners should have received copies of them as well. I believe there's at least one decision to make regarding Rule 1311. That was one of the ones where the commission asked us to present options. But otherwise, yes, you described the situation accurately.
Okay. A little bit out of order, commissioners, if it's okay. I know that one of our parties, Geothermal Rising, was an important stakeholder, and their attorney is only available for about 5 minutes this morning. Perhaps if I could, I'd like to elevate Mr. Lepore just to kind of get Geothermal Rising's position take on the red line draft before I know you've got other responsibilities you got to attend to. Mr. Lepore.
Good morning, Mr. Chairman. Good morning, commissioners. Thank you. Thank you for accommodating my schedule. Geothermal Rising is very satisfied with where the draft rules have landed. Really appreciate everybody's consideration, the parties, the commission's deliberations. We had a lengthy dialogue with other stakeholders over Rule 1320, and we are now satisfied with where that language is. We've expressed our opinions in the past about 1311, so I won't belabor those. Just hope you make the right decision. Mr. Chairman, anything else?
No, thank you. Appreciate your being able to accommodate the early schedule this morning.
Right. Thank you very much.
So, Mr. Boudreau, do you want to talk to us a little bit in further detail then about the one decision tree that's before us?
Yes, Mr. Chair. So we're looking at the bottom of page 44 of the draft posted to the docket. This is Rule 1311 for converting well bores from oil and gas well bores or any other type of well bore to a deep geothermal well. The commission asked us to present options. Initially as drafted, in order to convert a well bore, an operator would submit only a Form 2 to address the well and not a 2G to address the location. The commission asked for options regarding two situations. One is whether or not to also include a Form 2G to assess the location. And if the commission include the 2G, the commission instructed us to do what I believe is referred to as a 2G light. In other words, that 2G would only include that information necessary to reassess the existing location for suitability of the deep geothermal location. And the second option that the commission asked us to present was how to address notice of converting well bores. So at page 44, the two options would be either to include the 2G, and then we added 1311B1, which specifies that when submitting their Form 2G, a deep geothermal operator may omit substantially equivalent information previously provided either through a local, not omit, but that they don't have to redo the information, redo the studies or such, developed through a local government land use process, a federal agency permitting process, or a previously approved 2A. So if the location was already assessed under a 2A and the information is not substantially changed, then they can leave that out. So that would be the 2G light option. If you wanted to go with only the Form 2G, then we could strike all of the red lines language at the bottom of page 44. The second option that we were asked to present is one regarding notice. So there's two options at the bottom of Rule 1311 around the middle of page 45. Option one is if you want to provide notice to relevant and proximate local governments that a Form 2, and we can add 2G, was submitted to convert the well bore. Option two is what we call full notice. In other words, notice of completeness and public comment under Rule 1305D. I would note that 1305D, as the commission instructed us to amend it, now includes notice to relevant and proximate local governments. So option two would be full notice, notice of completeness, public comment, and notice to relevant and proximate local governments. Option one would just be the operator providing notice within 2 business days of submitting their Form 2 to the relevant and proximate local government. One side note, if you include 2G, then it by necessity includes notice to relevant and proximate local governments, but I don't see any harm in reiterating that at the bottom of 1311.
All right, commissioners, deliberation on this point. Commissioner Ackerman?
Thanks, Mr. Chair. I'll jump in there. For the purposes of beginning the deliberation, my initial leanings are towards the 2G light process with full publicly facing notice. It makes sense to me to reassess a site for geothermal operations. While there are similarities, there are also differences. My concern associated with that would be, can that process be used to unreasonably withhold permission from moving forward? I would expect us to have a site evaluation that was specifically based upon the stipulations of the regulations, and so long as it meets those regulations, it has an opportunity to move forward. And then I think full publicly facing notice is appropriate, as it is a significant and substantial change from an oil and gas operation to a geothermal operation.
Thanks for leading off. Others with thoughts? Commissioner Messner?
Thanks, Mr. Chair. I'll agree with Commissioner Ackerman. I do think while the Form 2 does contemplate downhole changes, as would be the case with repurposing an oil and gas well to a geothermal well, I think there's other service considerations, equipment considerations, best management practices that I think are best handled by a 2G light. And so I would agree with Commissioner Ackerman.
Commissioner Oath?
Thanks. First, I'll just really quickly want to generally and broadly say I think that the red lines look very good. I'm pleased with them overall. And on this point, we'll agree with Commissioners Ackerman and Messner. I think that in the types of cases we're talking about, there likely will have amount of time between an original approval of the site occurred and when we're looking at repurposing. makes a lot of sense to take another look at that and allow and provide notice and an opportunity to take a closer look at it in these types of cases. So agree with option 2.
Further deliberative thoughts? All right, well, I agree as well. Does any commissioner have other questions with regard to the draft that's now before us? Mr. Pedro, just for the record, I know that you had additional discussion with some of the other parties, in particular the allied local governments and Larimer County and others. Can you provide some perspective in terms of sort of where they're at relative to the draft that we have before us?
Yes, Mr. Chair. So taking a look at Rule 1320, as Mr. Lepore indicated, this was a situation where Mr. Lepore and Mr. Sura and also Ms. Kate Burke weighed in. This is the provision addressing Rule 211 and 503 G12B for converting oil and gas wells to geothermal, where the operator asserts that the well is used or useful in the future as a deep geothermal well. The parties agreed that for the first 2 years after the rules are promulgated, there'll be a rebuttable presumption that any well subject to a 211 application is, assuming that the operator claims to convert it to a deep geothermal well, the rebuttable presumption is that it is used or useful as a geothermal well. And beginning 2 years after that, after the rules are promulgated, the rebuttable presumption will be that it is not used or useful as a deep geothermal well if the operator has not applied to convert the well to a deep geothermal well before the 211 application was filed. And just a reminder, local government and surface owner can't file the 211 application until the oil and gas well has been low producing for 3 years. So there's kind of a delay built in there that gives operators a chance to apply to convert. There was also a discussion between, I believe it was Koga and Mr. Lepore or Geothermal Rising regarding notice to mineral owners. So this one was a little more complex than I think we originally identified during rulemaking or during the first 2 days of hearing. During my discussions with Ms. Ryan and Mr. Lepore, it came to light that what Koga is concerned about is mineral owners being able to access their minerals and not having all surface uses precluded by deep geothermal operations. So Ms. Ryan pointed me to a provision of the Colorado Revised Statutes, which, as I read it, applies to local governments and surface developers. And the basic idea is if you're going to develop the surface of an area, or if you have the local government considering permitting land use of the area, and the estate is divided so that the mineral estate is separate from the surface estate, the surface developer needs to contact the mineral owner and discuss and preferably enter into some sort of agreement by which a specific part of the surface will be set aside for potential future oil and gas development. And that in permitting land use, the local government should also take this into consideration. So it came to light that that was kind of what Koga was concerned about, was making sure that the surface use in the context of geothermal doesn't preclude future mineral development. Ms. Ryan kind of acknowledged that during this rulemaking, there may not be time to fully develop a scheme for addressing this situation. And so she asked if we could add it to the regulatory study upcoming in December, and then consider it in any future geothermal rulemaking if there are any. So that was kind of the agreement that Mr. Lepore and Ms. Ryan arrived at. So I put that into the SBP. I also met with Ms. Kate Burke in Boulder County, representing Allied Local Government. Big thanks to Ms. Burke for helping me sort through some of the typos and slight changes that needed to be made. Based on that, we added one line to the definition of, I believe it's proximate local government, to indicate that a proximate local government is a local government with land use authority within 2,000 feet of the proposed either working pad surface or geothermal pad surface. In Ms. Burke's view, that solved her concern about the way we incorporated working pad surface into the rules. And she also pointed out a place where we needed to make an adjustment to the language to match the definition of single well plugging and abandonment costs instead of plugging and abandoning cost. And so she seemed satisfied with the changes that we made there.
Thank you very much. And just for the record, really want to thank you, Mr. Boudreau and staff, for the dedicated work between last week and Friday when you got the red line turned. I think it's in excellent shape. I think it also is responsive to concerns that were raised by our various stakeholders. And I believe we've gotten to a place in which we have generated or can feel good about, at least from my perspective, voting in favor of the red line edits. And we've created a place for the cultivation of protective deep geothermal here in the short term. And as we indicated during our rulemaking in the last couple of days, we're, planning on sort of seeing how this goes and then moving forward and potentially revisiting as projects start to develop and we get a sense of what this looks like on the ground. Not to move into deliberations, but those were some initial deliberative thoughts from at least one commissioner. I don't know that we need to do anything more at this point. Does any commissioner have any additional questions about the draft before we sort of formally move into deliberations? Commissioner Cross?
Thank you, Mr. Chair. And I'll say I also support the amendments that have been made and the revisions that have been made. I did receive an email from one stakeholder that had a question about some of the testing that we made some changes to. And I was wondering if we could potentially elevate Mr. Rigby to explain one additional point. And this is more so, I think, for the public's edification overall on some of how the testing and logging is done. And thank you, Mr. Rigby. And so what I was hoping to get some clarification on that we can provide to the public is under the revisions that were made to 1311 F2, where we now indicate that it will require mechanical testing pursuant to Rule 417. It currently states with appropriate logging and or mechanical testing. And one of the stakeholders had a question about the and or mechanical testing versus requiring both. And I was hoping you could kind of explain to everyone what the difference is between those processes and why it's an and or.
Sure. In typical mechanical integrity testing, there's just pressure tests run on the well, pressuring the well up and seeing if there's any sort of change in pressure over time. Logging it usually goes above and beyond some of this testing to maybe run in the well with like a cement bond log. There are specific types of wells that we can currently under 417 require logging for injection wells. This provision actually just allows us to require logging or mechanical integrity testing depending on the situation. So it broadens what we're allowed to require to confirm mechanical integrity of the wellbore.
I appreciate that. And under the current mechanical integrity testing, that's usually a pretty good indicator that the well would be safe for a potential conversion, correct?
Yes.
Okay. Thank you. That's the only question I had. I just wanted to make sure that was clarified for the public overall and what those processes were.
Very good. Other clarifications, questions, etc. from commissioners? All right, seeing none, we move into deliberations. Does any commissioner desire to kick us off? Commissioner Ackerman?
Thank you, Mr. Chair. And during this hearing, we've heard lots of testimony unanimously from all sides in support of moving forward with deep geothermal operations. Much of that testimony also included friendly proposed amendments urging us to ensure that regulations are protective, especially during the pre-production phase, demonstrating that we kind of sit at a rare nexus of some overlapping potential incongruencies between two positive things that Coloradans value and are passionate about, and that's clean energy and environmental protection. And I just wanted to say I very much appreciated the positive approach to this rulemaking and to this issue from all sides. Concurrent with our ongoing rulemaking efforts, as detailed by Mr. Rigby at the onset of these hearings, the Commission dove headlong into the geothermal world, including attendance at geothermal events, particularly those focused on policy and/or developing geothermal areas, and lots of meetings with public and private entities and geothermal experts at all levels of governmental development and use. And this included, as mentioned by Commissioner Messner, a formal geothermal class through Top Energy Training in conjunction with Colorado School of Mines, as well as many discussions with innovators, developers, policymakers, and regulators, both in this country and in others. And I just wanted to say I found this intensive dive into geothermal energy to be particularly informative and helpful in preparation for this rulemaking. We've learned and spoken a bit during these hearings of the potential benefits of geothermal energy production. Among those are that it has the smallest environmental impact of all forms of energy. It has the lowest life cycle carbon footprint of all renewable energies. It's abundant, it's 24/7 clean technology. It's a great value as a renewable baseload energy source. And I wanted to recognize that much more depth on all of these issues can be found in the geothermal resource study, which was a huge lift by our staff and by others that contains a lot of information about geothermal, including information specific to Colorado. And Mr. Chair, I just wanted to take a second, and while many have worked on preparing ECMC in Colorado for moving forward with geothermal energy, I wanted to specifically mention, in addition to Mr. Rigby and AAG Boudreau, whom we've heard from during this hearing, Mr. John Morgan and Dr. Marie Horner from ECMC's geothermal team, as well as Bryce Carter from the Colorado Energy Office. Each of these folks has been lifting exceptionally hard to work toward geothermal energy deployment in Colorado. As we heard from Mr. Boudreau, the legislative declaration of the Geothermal Resources Act kind of helped us take this balanced approach that we're looking at today. It declared that development of geothermal resources is within the public interest for a number of reasons, and also admonished us to safeguard life, health, property, public welfare, and the environment, including wildlife resources, and correlative rights as we went through these regulations and deliberated over them. And while I'd very much like to see geothermal energy proliferate quickly in Colorado, including deep geothermal electrical production, district heating, thermal energy networks, single residence scale heat exchangers, and all associated direct and cascading uses, I agree that it's highly unlikely that there's any pending boom of deep geothermal development, but that we're rather more at a pilot stage. As such, I believe it is most responsible for the current and future well-being of the state, as it pertains to geothermal development, to strike a balanced approach to the regulatory schema today, as I believe we have done, helping kick off geothermal development in our state while setting in place appropriate protections that are amongst the most protective of regulations, while also taking into account the current and near-term expected state of geothermal energy development in Colorado. And I think Dr. Jones summed it up very eloquently, that all the discussions we've had are well-meaning, but failure to strike the correct balance could indeed hamper the industry. I believe the local authority granted to local governments by the Geothermal Resources Act creates a great balance by allowing localities to help dictate how geothermal energy will move forward in their communities within the broader framework established by the state. And I wanted to again mention and emphasize that we continue to analyze geothermal related issues in the geothermal regulatory study, as mentioned by Mr. Boudreau, and due December 31st. As well as keeping our eye on future necessity and or opportunity to review and revise rules as the industry evolves. So moving forward with jumpstarting the geothermal industry, in my opinion, will be a win for all Coloradans. As the environmental commissioner, I have a hope and vision that we will steadily march toward a renewable energy future in which geothermal electricity production holds a significant part. And as a commission, we're in the rare position to not only have a hope and a vision, but rather a tangible guiding impact on the future of geothermal energy in Colorado. And I, for one, do not want Colorado to be at a competitive disadvantage for the development of geothermal. I want Colorado to be the next focused frontier for geothermal development. And while this commission is allotted stewardship over deep geothermal operations only, I also hope to continue to see progress toward, as Director Tour put it, a new standard of implementation of geothermal in all forms in Colorado. I'm fully invested in helping move Colorado forward, both environmentally and technologically, and I'm strongly supportive of the governor's Heat Beneath Our Feet initiative. And as Iceland moved into a significant geothermal development in the mid to latter part of the last century, there was skepticism and trepidation about taking such a large step toward shifting core energy sources. While today in Reykjavik, the country's movement into geothermal is a great source of pride for the Icelandic people, who nearly ubiquitously laud the country's energy system, this transition alone helped move that country from a struggling nation into an economic leader, as well as a worldwide leader in broad-scale renewable energy adoption. So in my opinion, it's incumbent upon this commission to continue this major step forward in realizing the governor's vision of bringing geothermal investment, opportunities, and technologies to Colorado. It's critical that we do this by right-sizing our regulations. We can do this by providing a strong, predictable initial regulatory framework as proposed by staff and as modified during these hearings, and then continually monitoring the evolution of geothermal energy production in Colorado, appropriately addressing future concerns and opportunities as they arise. I believe these regulations are appropriate for Colorado, and I'm proud and humbled in having a role in helping Colorado move into this next new frontier of environmental prioritization and protection in its overall approach to energy development. While Colorado's geothermal resource is certainly different from that of Iceland's, it's abundant and accessible through existing and developing technologies. And these regulations will help pave the way for this industry to take hold in our state by establishing clear rules with significant protections that are characteristic of Colorado, while keeping establishment of the nascent deep geothermal industry in sight. And Mr. Chair, I would be pleased to move to approve these regulations as drafted by staff and amended as described by Mr. Boudreau once the time is appropriate.
Thank you for the initial deliberative thoughts, Commissioner Ackerman. The rest of the commission wants to thank you for your leadership in moving this forward with staff and with stakeholders. And obviously, you've gotten us to a really good spot, and we thank you for that leadership for sure. Other commissioners with deliberative thoughts? Commissioner Messner?
Thank you, Mr. Chair. First, I'll second Commissioner Ackerman's motion. And I think, Commissioner Ackerman, you've stated eloquently much of what I feel about the work that's been done on developing both the studies, the research around deep geothermal, the stakeholder coordination, and ultimately developing the draft rules that we've got in front of us. I feel like the minor revisions and clarifications to the draft rules through this rulemaking are reasonable and necessary to first meet the commission's statutory obligations, and secondly, to promote an efficient permitting process through clear communication, transparency, and coordination between the applicant and the different applicable reviewing bodies, which I think helps provide clarity, efficiency, and certainty, which has been expressed as essential to jumpstarting this type of energy development in Colorado. I really appreciate all the work that's gone into this. I think, as Commissioner Ackerman indicated, we've created a permitting process that is has the ability to both encourage geothermal development in the state and be protective of public health, safety, welfare, the environment, and wildlife resources. I'm very excited to see where the industry goes, and so appreciate all the work that's been done and would vote in favor of this.
And just one clarification on the motion in the second, just for the record, that motion is to approve the August 9th version of the rules, as well as the August 9th version of the SBP. And the motion is, those are red lines, and obviously we want to sort of clean it up by removing the red lines. Commissioner Ackerman?
Yeah, thank you, Mr. Chair. And included in removing those red lines would be the removal of the options and solidification as we've discussed today, if that makes sense.
Yes, it does. Commissioner Messner, your second is adjusted accordingly or refined accordingly?
Yes.
Commissioner Cross?
Thank you, Mr. Chair, and that was the point I was going to make, is just to make sure that we clarify the 2G light that we discussed at the beginning of this hearing today. I will be quick because I appreciate the comments that have preceded mine. I appreciate all the hard work that was done by stakeholders, that was done by staff. I'm very proud of the work that's been done on this to date, and I'm also very excited to see us take a new step in another alternative to oil and gas here, and make sure that we utilize the resources that we have in this wonderful state. And so I will also be voting in approval to approve the motion.
Further final deliberative thoughts? We have a motion and a second. Any further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? The motion carries unanimously. The deep geothermal rules are adopted, and we will get that posted on our website soon. Mr. Boudreau, do you know the effective date offhand for the rules?
I believe it's 20 days after they're published in the Colorado Register. According to my quick calculations, I think that's October 15th, but I'm not 100% sure. I'll make sure that's clear in either the SP and the SPP before we get it posted at the website.
Awesome. Great. Commissioners, that concludes the business of the day. We have a meeting on Wednesday. We look forward to that. At this point, I would move to adjourn. Do we have a second?
Second.
Multiple seconds. All those in favor of the motion to adjourn signify by saying aye.
Aye.
Aye. Great work. Great work to all of our staff and all of our stakeholders. We really appreciate that. And we're adjourned. See you soon.